We'll trickle in here, but so last week we left off, we talked about section 10.2. I think we left off at section 11. And so section 11 deals with cost of services that are being obtained by the broker. And so basically all it says is that the broker is not going to order any services or products from outside sources unless the buyers agree to pay for them when due. And so we had a broker at our Fort Collins office, and he had a listing where the title company said, hey, we are going to require an ILC, which is an ILC is kind of a dumbed down version of a survey. And so title says, hey, we need an ILC. And the broker says, okay, he calls up his seller and says, hey, seller, they're requiring an ILC. Do you want me to talk to my people, or are you going to order it? And the seller goes, oh yeah, you talk to your people and order it and whatever. So our listing broker, he contacts this survey company to come out and do an ILC. They come out and do the ILC. And then in the meantime, the contract between the buyer and the seller terminated, and the property never ended up selling again. This is not in this market. This was in a previous market. So the property never ended up selling. Well, the seller at that point is like, well, hey, I don't really want to pay for this ILC since the property never sold. I never would have got it by myself anyway, right? And the broker's like, well, you told me to order it. And the guy's like, well, you never told me it was going to cost me anything. And so neither one of them ended up paying it. And then all of a sudden, the survey company ends up sending our broker to collections. And so, our broker takes a ding on their credit, and all this other stuff got super ugly. And so at the end of the day, our broker ended up eating like a $500 bill for this survey, and got his credit dinged and all sorts of other stuff. So if you're going to order something like that, not only should you have agreement from the buyer that they want you to actually order it, but you should get something in writing saying, yes, I agree to pay for it as well. Okay. And it gives a list, and this is just some examples. This isn't all inclusive, but stuff like surveys, radon tests, soil testing, title reports, engineering studies, property inspections, really anything else that you're going to pay for in conjunction with your real estate transaction. Okay. Neither the broker nor brokerage firm is obligated to advance any funds for the buyer, and the brokerage firm certainly is not. Not a good idea for you as a broker to advance any funds. If you are going to, you should probably talk to an attorney and have an attorney draft up some kind of an agreement that is not an agreement that we will help you draft, because you shouldn't be doing it in the first place. And then the buyer has to reimburse the brokerage firm for payments that were made by the brokerage firm if those were authorized by the buyer. Okay, and so in the case of the survey, like, we probably had the right to go after the buyer for this ILC. The buyer said, oh yeah, you can go ahead and you can order it, whatever. Well, that being said, we never told the seller, hey, it's going to cost you $500 or whatever the cost of the survey was. And in the meantime, our broker's credit took a hit, and that was, wasn't going to be reversed anyway. So just be careful about how you're doing that, what you're doing. And really the best practice is just don't pay for anything out of your pocket unless that's something that you just intend to pay for and not be reimbursed for. Okay. Because the problem is, if the buyer fails to pay you back, how are you going to get that money back? You're going to take them to court. You're going to take your own buyer to court for something. Like, it's just not a good look to be suing your own clients. Okay. So section 12 talks about brokerage services and showing properties. And so section 12.1 says, the following additional tasks will be performed by the broker. So these would be any tasks in addition to your brokerage duties that you've laid out in section 5, the additional duties of a buyer's agent that are spelled out in section 6. Is there anything else in particular that you're going to do? If you're going to, if part of your deal to, try to hook buyers is that, hey, like, you tell me a neighborhood that you're interested in, and I'll send out a bunch of postcards and see if you can, see if we can turn up an off-market deal or something. Like, if that's a significant part of your buyer's decision, you can go ahead and you can, write that type of stuff in here. You just have to be careful, because anything that you write in here ends up becoming a material obligation. And if you fail to fulfill one of your material obligations, the buyer has the right to terminate the contract. Okay. So generally speaking, I don't really put anything in here unless there's something very specific that the buyer, has requested of me that I've agreed to do. I just leave it blank. Okay. As far as showing properties, so buyer acknowledges that you've explained all the possible methods used by listing brokers as far as access to the properties and whatever your limitations are. This isn't really something we have a big issue with, right? Most brokers in our area are still using the old school lock boxes that have like the dials on them, right? Or whatever, including myself. I'm not making fun of anybody, but a lot of other areas in the country have moved exclusively to electronic lock boxes, whether it's Central Lock or Supra or something else. We seem to be kind of a holdout and we still use all the old school lock boxes. So nothing is fail proof. I've seen ways to hack Central Lock and Supra and all these other various methods, right? Nothing is fail proof, guys. So whatever your limitations are as far as accessing properties, maybe not just the lock boxes themselves, but maybe you say, hey, I'm not available to show properties on Sundays, or not available to show properties after 7:00 p.m. Like whatever your limitations are, put it here. And then, you have a legally binding agreement that you're not obligated to, show properties during that time, or whatever your case may be. Okay. Again, I don't typically put anything there. Sometimes I'll put like limited by seller showing instructions, right? If I can't get in because the seller won't allow it, then I can't show it to you, right? But other than that, like I'm going to show property when I'm going to show property. That being said, totally respect people who have a set schedule and they don't want to show properties on a particular day because that's their day off, or after a certain time because that's family time. I get it. So you need to decide what works best for you. Okay. And then there's a blank here that just says, hey, the broker has access to the following MLS. And so you could put Iris, RE Colorado, Pikes Peak. If you happen to be a member of some other MLS, you could put that information here as well. Okay. As far as disclosure of the buyer's identity, so this is not asking if you can like sell their information on the dark web. This is just like, can you or can you not disclose the buyer's identity to third parties? And this is really like in conjunction with the transaction. So, if we're talking about a home inspector, right? Can you set up the home inspection on behalf of the buyer and disclose the buyer's name and their email address and phone number to the inspector, right? Or do you not? If you don't have that authority, then either the buyer needs to set that stuff up themselves, or you need to set it up and have it just delivered to you, and then you can forward it to the buyer. Okay. But generally speaking, I just check the box that says, yes, I do have the buyer's permission to disclose their information to third parties. Again, you shouldn't be selling your client's information to anybody. So don't do that. Okay. As far as disclosure of settlement costs, so there's different qualities and costs associated with different service providers. So when we talk about attorneys and lenders and inspectors, title companies, engineers, anyone else who might be involved over the course of a deal, really the real estate commission says that we should be giving our clients, they say a minimum of 3 people is who we should recommend. Now, that being said, it's a real estate commission position statement. Okay. And there is a difference between a commission position statement and a real estate commission rule. Position statement is effectively something that the real estate commission provides to brokers as a way that they're trying to keep you out of trouble. They're trying to limit your liability, right? Whereas a real estate commission rule, if you violate a real estate commission rule, they can fine you up to $2,500 per rule that you've broken per offense. They can require you to take classes. They can downgrade your license level. If you happen to have an independent license or an employing broker's license, they can downgrade you. They can put you on suspension. If it's serious, they can revoke your license, right? So it's a commission position statement that they say, hey, you really should refer 3 people. Now, when I'm referring title companies and inspectors and those type of people, I still generally refer 3 people. And, generally speaking, they're going to go, hey, Angela, thanks for the recommendations. Who's your go-to out of these 3? So what are you going to do when somebody, and I'm not picking on Angela, anyone can answer the question. You give them the 3 and they go, hey, out of these 3 that you provided, who's your go-to?
I just tell them, Jesse, that I've vetted all of them and that I feel very comfortable recommending all 3 and that I'm handing that ultimate decision off to them.
Yep. So perfect response, right? The whole point of providing 3 people is so that you're not steering them in the direction of just one person. And, a lot of people want to have an exclusive relationship and whatever. And I get it because I've been there and I've done it. And I'll tell you, I didn't really fully understand the importance of that until I had a title company that missed a $17,000 lien on a property. And it was the title company that I recommended, right? And so then the seller looks at me like, hey, this is the title company that you recommended. They missed a $17,000, lien on my payoff. And here we are 2.5 years later, and now they're requesting an extra $17,000 from me. And in the meantime, this lady's husband had gone to jail, and she's a single mom with 2 girls trying to work, and she'd blown through all the equity that she made at closing. She didn't have $17,000. And yes, it was a lien against her property that, she should have been responsible for and everything else. But why is this coming up 2.5 years later, right? And fortunately, she didn't come back and sue me or anything like that. But certainly she could have. She could have said, hey, Jesse, this is, the title company that you recommended, and they missed a $17,000 lien on my property. And here we are 2.5 years later, and I'm having to deal with it. I don't have it. Right. And so now it's going to negatively affect her credit and everything else. Right. If she would have filed a real estate commission complaint against me, I probably would have been, popped for, whatever various, I probably would have been fined and had to take classes and whatever else. Right. That's not like a revocation type deal where they're going to revoke your license, but absolutely they could look at it and go, hey, yeah, you didn't do what you were supposed to do. And they would try to twist it, I'm sure, because again, keep in mind, it's just a position statement that says you should refer 3, right? But if you don't refer 3, they're going to look at it and they're probably going to go, okay, well, we can lump this under this new competency rule. You're not competent because you didn't refer 3. And, we feel like you're steering your clients in the direction of this one title company and whatever else, right? So best practice is to refer 3. Anytime you're going to refer somebody, refer 3, right? And then if they say, oh, hey, thanks a lot, who's your go-to out of this list? I think Angela had a perfect response. I vetted all these and I'm comfortable referring any of them to you. Call any of them, whoever you're comfortable with, and make the decision. That they're not going to do you wrong, whatever. Right? You can give them your little spiel. But it's a good idea to have your list of 3 people so that when they ask, you're not just sending them to the one person all the time. Okay.
Jesse, how do you approach if with the market that we have right now, and I know you mentioned it the other day in one of your classes, how do you approach it if you're trying to get your buyer's offer accepted and they have a preferred lender? So how do you approach that if you may want to swing that way?
Yep. So what Jerry's referring to, so we did a class a few days ago that was some ways that you could compete in a competitive market. And so one of the things that we talked about was ask the listing broker who their preferred lender is and have your buyer use that seller's preferred lender, right? Because if I'm a listing broker and a buyer comes to me and says, hey, we want to know who your preferred lender is, then that might carry some weight as far as me and how I advise my seller. Because if a buyer goes to my preferred lender and goes through the pre-qual process and everything else, and my lender says they're good, I know they're good, right? And so I have a little bit more trust and I have a little bit more faith in them compared to someone who might be using their own. Okay. And so it's perfectly acceptable to give your client, right, the list of 3 or whatever, and then say, hey, if you want to be competitive, one of the things that we might try doing is asking the listing broker who their preferred lender is, right? And so that then it becomes up to the buyer, like, hey, do you want to work with, maybe they brought a lender into the deal, and you've provided 3 and whatever else, and then they go, hey, yeah, if that's what it's going to take to lock down a home today, then yeah, I'm willing to give it a shot because I've already been beat out on 4 other offers, right? We got to find something, we got to get it going. So, yep, I'm willing to work with their lender, right? No harm, no foul, but at least still give them the 3 recommendations and say, hey, is this something you want to do to make your offer competitive or not? And really advise them, hey, I don't know this lender's costs and fees, and maybe you've never worked with them before and whatever else, right? Like, you're taking a risk, and maybe you're taking a risk in working with them. Maybe they're going to be awesome. I don't know, because I don't have a relationship with them, but clearly the listing broker does, and that might help to get your offer accepted. Do you want to do it or do you not?
And then get that in writing.
Yeah, I mean, not a bad idea to get
Right.
any of this stuff in writing. Yeah. Someone else have a question?
Yeah, Jesse, I've got one. So title is a little bit weird because, title is, I mean, nothing that a general consumer really truly understands.
Mhm.
So they kind of do rely on us for that piece. I ran into that with a seller recently. How do you handle that specifically, especially given the situation that you experienced with the $17,000 loss?
Are you referring to like just simply referring 3, or are you talking about when you get a title commitment and like
No,
helping
I'm
them
talking
understand?
I'm talking about referring them.
Yeah, so First American used to be my go-to, right? And so that was the one and only that I would ever provide, because most consumers just don't have a relationship with a title company,
Exactly.
right? And so my First American was always my go-to. And then lo and behold, they screw up this one deal to the tune of 17,000. And so that kind of made me realize, like, okay, there's a reason, right? And if you've heard some of my other classes, right, you've heard me talk about, like, brokers always see things as rainbows and unicorns. Everything's always golden, right? And that was really the light switch for me, right? Of, okay, this is why they have this commission position statement that says we should always refer 3. And so after that, I went out and I started interviewing title companies and closers and reps and everything else. And so now I just have my list of 3. Same thing as any other referral. I just say, hey, here's my list of 3 title companies that I work with. They're all pretty close as far as rates. I'm comfortable with all of the closers' levels of service and their responsiveness and their communication and everything else, right? So pick, who do you want to go with? Doesn't matter to me. And your title companies, like, they're not always super excited about that, but because they want to have an exclusive relationship with you. But at the end of the day, I just tell my closers, like, hey, I spread the love. Like, it's not anything against you. I spread it out to minimize my liability. And a lot of times, if you tell them the story, right, and probably you haven't been burned at the tune of $17,000, but if you tell them the story, right, then it makes a little bit more sense to them. Like, okay, yeah, I can see why you want to provide a list of 3 people and whatever else, and they get it. So but I'm good to all my closers, regardless of which 3 it is, right? And I'm not trying to sway you to one particular company or another, but go out and talk to 3 so that you can feel good about referring your client to 3 title companies, just like you would an inspector or a lender or anything else. There's plenty of good options out there.
Thank you.
Yep. Any other questions on that piece? Okay, wire fraud. So this was a section that got added into our contract a couple of years ago. Just kind of a warning that, hey, wire fraud is a real deal. It is becoming increasingly a problem. And fortunately, title companies have started moving to like secured emails and everything else, but still, I don't just flat out trust a secure email either. Okay. And so anytime they're supplying that confidential info, they should provide the information in person or in another secure manner. And so really what I tell my clients is, hey, if you're ever going to wire any money, whether it's the earnest money, whether it's the cash to close, whether it's any other, form of payment, if you're going to wire money, what you need to do is not just rely on whatever the wire instructions that you got via email say. Well, you need, and the other piece is you need to not just call the phone number or anything else that's listed on those wire instructions either, because what's happening is these hackers are effectively intercepting these emails, and they have very complex and complicated systems that allow them to kind of filter the emails, right? And when they start seeing there's words that will trigger them, right? And then they intercept it, and they replace those wire instructions with fraudulent wire instructions that have a different account number, different routing number, right? And in some cases, they'll even change the phone number so that if you actually go to try to call that phone number, the phone number, is hooked up to the scammers too. And you call them and go, hey, I need to verify the wire instructions. And then you read off the fraudulent account to them and they go, yep, that's great. And you think you're good, and you wire the money and it's gone. So what you need to do is, once your client has those wire instructions, let's say you're working with Heritage Title, right? You need to have them Google or, go to some internet search engine, right? Look up Heritage Title and call the phone number that's listed there. Hopefully it's the same as what's on your wire instructions, but call their main number and just say, hey, I need to verify wire instructions before I send money. Really, anyone who answers the phone there should be able to help. They do it all the time. They understand, they know what's going on, and they should be able to verify those wire instructions for you, right? And they'll say, okay, here's the account number, here's the routing number. It needs to be, made out attention to, whatever whatever subject line and everything else. And as long as that matches the wire instructions, that's great. Okay. But it's a step that you guys need to advise your clients to take. And so I'll remind them several times throughout the deal, like, hey, don't wire any money until you've had a chance to call me, right? Because I want to review this in person with you. I don't simply want to rely on this little one-liner of like, hey, wire fraud's dangerous and you could lose a lot of money, right? I want to help them be able to figure out, hey, how do I overcome this? What are the steps that I need to take in order to hopefully prevent this wire fraud from happening, everything else? Because once you wire it, it's gone. Okay. So any questions on wire fraud stuff?
Jesse, that's disclosed on their closing instructions too.
Well, again, like what happens though if their
then,
closing instructions are hacked or something else? I mean,
No, I meant that form that they sign when they go, well, typically it's on the listing. So they have their closer that they're using. So I refer them to that and then I just send them another email with that information on.
Yeah. Yeah. Good idea to just, remind them several times throughout the deal. Like, hey, before you wire any money, call me, right? Because inevitably what happens is the closer sends out the settlement statements right prior to closing. And then the buyer goes and they're like, okay, I just need to wire this money. I already have the wire instructions. And then they'll go do it without ever talking to you about it. Thinking like, oh yeah, the wire instructions that I have are golden. And, fortunately, I've never had an issue with it. Every time that, I've had a client who gets the wire instructions, they're always correct. They've never been tampered with. But there are some local closers here who I've talked to, and they have actually stopped, prevented wire fraud from happening because their emails were hacked and, fraudulent wire instructions got sent out. So it is happening. It has happened locally. It is a problem. So just be super careful because that devastates somebody, right? They go wire a couple $100,000 and it's gone. Like that's just a horrible day. Okay.
Jesse, I have a question.
Yeah.
So yesterday I got an email from Land Title Guarantee Company in Pueblo that my documents are on the way for 2330 Longhorn Drive. I have no idea what that is. What do I do? Call them?
Yeah, is it listed? Is that property listed?
I don't know. I haven't checked.
My guess is, since you have a kind of a common name, there might be another Gary Miller out there, and they may have like popped your email in by accident instead of the other Gary Miller, or they may have associated you with the wrong transaction or something like that. And so you may have been copied on something, but yeah, I would probably refer back to whichever title company sent it and just say, hey,
if
like,
the property
I don't know.
is listed.
Yeah, so probably refer back to the title company and just say, hey, I got these documents. I think you maybe sent it to the wrong agent. I have nothing to do with this. Mistakes happen too. So
Okay.
I doubt there was anything fraudulent there, but you know, when you have a fairly common name, sometimes that's bound to happen, right? So,
Right.
um,
Very good. Thanks.
yep. So section 16 was added recently as well, and it talks about removal of marketing material. So just as buyer acknowledges that, you know, any of that marketing material that gets used, once it's out there on the internet, it's kind of impossible to remove in some cases, right? And so, you know, if you go look at a home that's sold on Zillow, right, you can still pull up the photos from the previous listing, even though it's sold. And in many cases, it's very difficult to get those removed. And so, you know, there's people, you know, particularly like law enforcement, for instance. I was in law enforcement for a few years, and a lot of those people want their address, you know, obscured from public records, and you know, the county is willing to do that. There's actually a form that law enforcement can fill out that says, hey, we're going to wipe your info out of public records so that somebody can't search for Jesse Engel in public records and find your address. And so there's stuff like that that is you're able to do. However, Zillow and whatever other sites you might market to, they're not obligated to do that. And so there's been buyers who have, you know, a particularly sensitive situation, or they, you know, need the privacy or whatever else. And so, you know, they're like, oh, I need the listing photos to be removed after closing so that nobody else has access to those. And lo and behold, it doesn't happen. And then they end up suing the brokers for failure to remove the marketing materials and everything else, which we are supposed to remove marketing materials as best we can. But they added this clause in there to essentially protect brokers from, you know, buyers who say, hey, like, I need it removed. And then, you know, we can't get it removed because, you know, Zillow won't take it down or whatever other website. So just a little disclaimer that, hey, it might be difficult for us to remove anything, you know, once it's on the internet, it's on the internet. Okay.
Hey, Jesse, real quick.
Yep.
What would be an example of something that you remove once a home is closed?
So, for instance, like you should, if you have a single property website where, you know, you 123mainstreet.com, right? Those are websites that really theoretically should be coming down because it's not an IDX feed. It's particular to your listing. It is a, you know, a website that is tied to one listing. It's not like a search type portal. So those types of things are things that should come down.
So you're talking like a landing page.
Correct.
Okay.
Okay. Non-discrimination, guys, just don't do it. You know, there are things that you can discriminate against as long as it's not a protected class. That being said, some of these things blur the lines between, you know, is it a protected class or is it not? You know, I think most of us are aware of all of the, you know, typical protected classes, but, you know, you get stuff like religion, right? And you have the Church of the Flying Spaghetti Monster. Like, was that ever intended to be taken as a real church or was it not? I don't know, but you can't discriminate against people who belong to the Church of the, you know, Flying Spaghetti Monster or whatever it is, right? Like, not a good idea to discriminate, generally speaking. However, there are some things, you know, if you don't want to work with an attorney, right, then you probably have a right to do that, because at least as of right now, occupation is not a protected class. It may become a protected class at some point in the future, and it probably is in some other states and whatever else, right? But you know, so there are some things that you could potentially get away with. But if it has anything to do with any of these protected classes, and this is federal or state or local protected classes, then just don't discriminate against them. If you guys have taken the 2021 annual commission update, you'll know that Colorado recently added hairstyle, and that wasn't done to, protect the guy with the mohawk on the street. That was done because, there are certain people who have certain hairstyles based on their culture, based on their religion, right? And so it's kind of tied into some of those other protected classes. And so hairstyle is now a thing in Colorado that we cannot discriminate against. And it doesn't go into detail as to, hairstyles associated with a specific culture or religion or whatever. And so if you're like, hey, I don't want to sell the property to bald guys, like, I'm sorry, but you don't have an option to discriminate against the bald guys. So know your protected classes, and really just best practices, just don't discriminate, period. Again, there might be a couple caveats to that, but just generally speaking, not a good idea to discriminate. Okay. That being said, just because you select one offer over another doesn't mean that you've discriminated. If it's based on the terms and conditions and everything else in the offer, then that's fine. If it's about the offer, if it's about, hey, we don't like these people, we don't like their offer because of who they are or what they look like or what they believe in or whatever, then that's discrimination. But if it's, hey, I have two offers on the table, take all the protected class stuff out of it, this offer we like better for these reasons, and you have an objective by which you are, reviewing these offers, that's fine. You also don't have to take the best offer from a bottom line standpoint. It's certainly feasible to take an offer from, that might have a lower net to the seller. And so one of the things that is fairly common, right, is that in some cases people say, hey, like, yeah, I get that this VA offer, the buyer's a vet, and, maybe it's not the best offer, but we want to throw them a bone because they served our country and whatever else. So we're going to take an offer that maybe isn't necessarily our best offer. Okay, that's seller's prerogative to do that. They can do that. It's not discrimination. It's not anything like that. So that's okay. Other instances, like if somebody came to me and they were one of my friends and I was selling my home, I might be willing to, throw them a bone and sell it to them at a little bit less than I might sell it to someone else for, even if it's not the best offer. So that's okay to do. So don't get roped into like, oh, you're discriminating because you didn't accept our offer, but have some kind of objective criteria and be able to explain why you accepted the offer that you did. And hopefully it has nothing to do with any of this stuff. Okay. Any questions on that piece? Okay, recommendations of legal and tax counsel. So, this is on pretty much all of our contracts. This form has important legal consequences. They have a right to talk to an attorney, tax, CPA, whoever they need to talk to. And if it's beyond the scope of your expertise as a broker, don't try to advise them on things that you shouldn't be advising them on. Just be careful as far as that goes. Mediation. So keep in mind, this is mediation between you as the buyer's agent or buyer's broker and the buyer, right? So if there's a dispute between the two of you, then this mediation clause comes into play. There's a similar clause in the contract to buy and sell. And effectively, there's a little bit of a misconception that people believe that you have to go to mediation. It's not entirely true. That's really the intent, is that you should. However, if you request mediation and the other party stalls for 30 days and they won't go to mediation, they won't appoint a mediator, whatever, the situation is, if you can't get it resolved within 30 days, then the parties have the right to proceed to arbitration or litigation. So you don't always have to go to mediation. However, what the contract says is that the parties in good faith agree to proceed first to mediation to try to get it resolved. And so, in some cases, what happens is like one party says, hey, let's say it's the broker. They say, hey, buyer, we request your presence at mediation so that we can resolve this dispute. And the buyer goes, okay, yep, let's try to appoint a mediator on this deal. And then the broker is like, I'm not going to mediation. I just sent you the notice because I wanted to start the 30-day clock so that I could end up suing you and take you to court. Well, in some cases, the judges have remanded that back and they've said, hey, that you're not going to be able to proceed to litigation until you have actually gone through mediation. In some cases, they say, okay, if you tried to appoint a mediator and you guys couldn't, pick a mediator or whatever the case was, then yeah, let's move forward with a lawsuit. Okay. So you never really know what the judge is going to say, but there have been certain circumstances where one party just refuses to go to mediation because maybe they feel like they have an incredibly strong case and they don't want to waste money on mediation, right? They will just want it to go straight to the judge, because if the parties do go to mediation, who pays for the cost of mediation? You guys know? Who pays for mediation if the parties go to mediation?
Both.
Yep, it's split equally between the parties. Okay. And so if I have a really good case, I might not want to, split the cost of mediation. I might want to just say, hey, no, I'm not going to kick in any money here. I just want to go straight to court. So I might refuse to go to mediation. Now, you got to be careful about doing that. It's not really operating in good faith, and it could get kicked back, but that is something that happens. The other piece to know as far as mediation is concerned is that the mediator can't impose a binding decision. So, if the parties do go to mediation and they can't agree on something, the mediator has no authority to make the decision. Okay, it's just if the parties agree at mediation, then it will be binding. If they don't agree, then you have no binding decision. Move on to litigation or arbitration. Okay.
Where do you go to look for a mediator, Jesse? I mean, I'm just.
Yeah. So honestly, a lot of like retired judges will do mediation, and attorneys. There's some attorneys firms that specialize in mediation. Before you personally ever go to go try to find it,
I'll talk to you first.
Yeah, your first call should be go talk to your employing broker. Okay, that's where you get mediators from. I don't want you guys trying to address this stuff yourself. We need to notify E&O and all this other stuff. So your first step should always be talk to your employing broker. Okay. What else was I gonna say? Any questions as far as mediation goes? Typically, a mediator's well, first things first, in most cases, it doesn't make sense to go to mediation. Okay. When we're talking about a $4,000 earnest money deposit, right? Mediation is probably going to cost anywhere from $1,500 to $2,000, maybe more, depending on the case. Like by the time you go to mediation and pay for it, you're eating into a significant portion of that earnest money. Now, if we're talking about $50,000, then yeah, it might make sense to go to mediation. But in most cases, you know what the mediator is going to tell you? They're going to say, split it, because it'd be really dumb to go to court over $4,000. Right. And again, that's more between a buyer and a seller, right? Really, the mediation piece between a broker and a buyer would be some kind of commission dispute. Did you earn your commission or did you not? Right. And again, probably the mediator is going to tell you, hey, like, you should probably just split it, because by the time you get attorneys involved and everything else, it's just not worth losing, legal fees out of that commission. You've eaten into the entirety of your commission by the time a commission dispute gets litigated. Okay. So in most cases, a mediator is probably just going to tell you, hey, I really don't care who's right and who's wrong. It's really stupid for this to go to court. So split it and move on. Okay. Section 20 talks about attorney's fees. So if let's say you move past mediation and you go to arbitration or you go to litigation in regards to this listing contract, a buyer listing contract, then the court must award to the prevailing party all reasonable costs and expenses, including any attorney's fees, any legal fees, any of that type of stuff. Now, even though it is very black and white in this contract, what I will tell you is that in many cases, either the judge will say, hey, yep, you're in the right, you win this deal. However, I'm still assigning you your own legal fees and attorney's fees. And, the other party's going to have to pay for theirs. They have the right to make that decision. The other thing that we see a lot is if there's a dispute, the parties will, typically get through part of the process, and then eventually they'll come to some kind of settlement. And as part of that settlement, almost always the parties agree that they're going to take on their own legal costs and attorney's fees. Okay. So unfortunately, our legal system gets abused, and that's part of the deal, right? Even if you're in the right, in some cases, you're still going to have to pay your attorney's fees. But we do have a provision in our contract that hopefully you will be awarded attorney, that the other party would have to pay for your attorney's fees if you win. But on the flip side, you might end up taking all of the attorney's fees as well. Okay. Additional provisions. So what do you notice about additional provisions? This section is blank, right? And really there's not a lot that I typically recommend writing in here. If you guys were on the class last Friday, one of the things that we talked about is, in some cases, what brokers want to do is they'll go up to, let me get back up here to section 7. What they'll do is they'll say, in regards to section 7.3.3, the buyer is not obligated to pay a commission, right? And then they'll come down to the additional provisions, and they'll say, hey, buyer, yeah, you're not obligated to pay my commission. However, if you want to see a FSBO or a property that, is not offering a co-op commission, you agree that we're going to negotiate some commission before, I show you this property, right? Well, agreeing to negotiate really does nothing for you, okay? And so if that's the case and Jerry is my buyer, and Jerry's like, hey, Jesse, I want to go see this for sale by owner. And I look at it and I call them and they're like, yeah, no, we're not paying any commission. It's like, okay, Jerry, they're not paying any commission. We have this, agreement whereby we agree to negotiate a commission. So, my success fee was 3%, and I like you, you're my friend. And so I'm not going to stick you with the 3%. I'll do it for 2%, but that's got to come out of your pocket. Sound good? And Jerry goes, no, you agreed to provide brokerage services for me, and I'm not going to pay 2%. I'm like, okay, well, I got to get paid something. So how about we do it for 1.5? And Jerry says, no. Right. And I'm like, okay, Jerry, how about 1%? Jerry says, no. I'm like, okay, how about $5,000, 2,500? Jerry's like, no. Have we negotiated a commission? I mean, we've negotiated, doesn't mean we've come to an agreement, right? But we've negotiated, and that did us no good. It didn't do us anything. It didn't get us anywhere. And I'm still obligated to provide brokerage services because section number 1 in our contract says that I will. So putting that type of provision in this contract really does you no good, right? And so then people say, well, I'll just, I'll put a provision in here. I'll put 3% as my success fee or 2.8 or whatever. And then I'll come down to additional provisions and I'll put in additional provisions that, hey, I won't pursue you for anything less, if they're offering 2% or more, I won't pursue you for the difference between the 2% that they're offering and 2.8 or 3% or whatever your success fee is. I won't pursue you for the difference as long as I get at least 2%, and they'll put that in here. Well, you don't really need that, right? You can just come up here to section 7.1.1 and put your success fees equal to 2%, right? And you still have the protection up here that says you're entitled to receive additional compensation, bonuses, and incentives paid by the listing brokerage firm or the seller, right? So I can put 2% here, meaning, hey, buyer, I won't, put 2% there and check the box that says the buyer is obligated to pay, right? And then effectively what that means is, hey, buyer, as long as they're paying me at least 2%, I'm not going to come after you, but I'm still entitled to receive 2.8 or 3 or 3.5 or whatever it is that they're offering as far as the co-op commission. That's the way you do it. You don't need that verbiage down here in additional provisions. Okay. So
Jesse, when you're sitting down with your buyers and you're having that discussion going through this with them, you don't know that at the time. So are you saying you go back and you do another one, or what's the conversation? I've had this happen several times, and I've just sat down with my client and said, here's what we're looking at, here's the ramifications, and let them decide. But it never went to, well, I'm not going to pay you anything. And this is, the for sale by owner as well.
Yeah, so it kind of depends on when you're filling this form out, right? If you're filling it out at the first, your first meeting,
Yep.
then yeah, you don't know what the commission is
Right.
going to be. But at the same time, if you do that, do you want to work for free or do you not? Right? If
Have
you
that
don't,
tough conversation in the beginning, say, this is what could possibly happen. And I explain, I'm not, covering liability and, representing you for free. I need, granted, I have a family too. So, but anyway, I just let them know that that's a conversation we're going to have down the road if that happens. And these are the scenarios that could happen.
yep. And you just got to be careful, because if you sign this up front and you say that buyer is not obligated to pay,
No, I pay
right?
is.
And then I know I'm not saying you, but
Right,
if you
right.
check the box that says, hey, buyer, you're not obligated to pay, then telling them down the road, like, hey, this is a conversation we may need to have if this particular situation comes up. Like, there's no conversation to be had. The buyer's not obligated to pay, then it's not a conversation to have, right? So if you want to protect yourself, then the way you do it is you check the box that says your buyer's obligated to pay, and it doesn't have to be your full, whatever you expect a full commission to be, but what are builders doing right now to co-op commissions? They're cutting them down, right? And in some cases, like Lennar, for instance, there's many Lennar locations where they're not cooperating with brokers, period. And so if your buyer goes to pursue new construction and they go purchase a Lennar home, there's a good chance you're just going to get hosed. But you're still on the hook to provide brokerage services to them, and you're supposed to take on liability in that deal. And those contracts are very geared towards the builder. They don't give the buyer a lot of outs, right? Those are the deals where you have more liability. And so putting yourself in a position where you're not, you have nothing to show for it is just risking your own livelihood, right? So pick and choose what you want to do. I'm not here to tell you one way is right and one way is wrong, but know what the consequences are based on how you're filling out this contract. Okay. Attachments. So generally speaking, we don't have a lot of attachments associated with this contract. I don't know that I've ever attached anything to an exclusive right to buy. In some cases, on an exclusive right to sell, I might attach like a marketing plan or something else. But again, if you attach a marketing plan on an exclusive right to sell, those become part of your material obligations, which you're obligated to do. And if you fail to do them, the buyer can terminate the contract and get out of it unilaterally, right? If you fail to fulfill all of your material obligations, okay? As far as physical delivery notice, obviously any document or notice, it needs to be in writing unless it's, it needs to be, physical copy in writing unless, section 23.2 allows for it. And section 23.2 allows for, documents to be delivered as noted, electronic notice either at the electronic address of the recipient by fax, email, right? Some people will put DocuSign or CTM or internet or whatever here. Really, email probably covers most of that, but certainly doesn't hurt to add whatever, CTM or DocuSign or whatever program you're using, okay? Electronic delivery of those documents may be delivered by, those things that we talked about, a link or access to a website. So this is why I say DocuSign, CTM, right? That stuff is pretty much covered based on the standard language in here anyway, or at the fax number of the recipient. Hopefully you guys aren't faxing anything. Too many issues with faxes. Too many people don't know how to use them. I don't know why they still exist. I mean, yes, they are much harder to hack. So that's why a lot of government entities still use faxes, but I should just prevent yourself a lot of brain damage and just don't fax, okay? Choice of law, if something were to, if there was some kind of dispute in regards to this contract between you and your buyer, Colorado state law would be used to, determine the outcome of that dispute for any property that's located in Colorado. If this contract is modified, then it needs to be done in writing, and it's not enforceable unless it's in writing and signed by all the parties. There have been some cases where, even if only one person signs, and let's say you have two buyers, right? Even if only one person signs, that the courts have still held that to be sufficient. In some cases, not all. But part of what our contract says, right? We define the buyer as, maybe we just define it as Mrs. Buyer, right? Just the one person. But what it says is, and any other person or entity on whose behalf the named party here acts, right? Whether it's directly or indirectly to purchase the property. And so if only one buyer has signed this, and they go buy a property with Mrs. Buyer and Mr. Buyer together, right? That probably still is going to mean that they're obligated to pay you a commission in conjunction with this deal, because that one buyer, Mrs. Buyer, acted directly or indirectly on behalf of Mr. Buyer as well.
Wait,
Okay.
Jesse, you said that example, like, was it last week or several weeks ago, where they were going through a divorce, remember? And that came back to bite you because she signed it, but he didn't?
Well, so
Right?
I think the
No.
one you're referring to, it wasn't really a divorce case, but
Oh.
what happened was there was an expired listing from another brokerage firm, right? And one of our brokers had a buyer, and they had actually submitted an offer on this property, and they were too far apart, right? But it had been listed previously for a whole year, and on day 365 it expired, and then they relisted the property, and now we're on like day 363 of that second year, that the property had been listed. And so our broker looks at it and goes, hey, this thing has been listed at, it was originally listed for a full year and it expired. They relisted it and we're on day 363, right? When do you think that this property is going to expire, this listing? It's probably going to expire in the next 2 days, right? And so what our broker does, our broker goes, okay, it's been on the market now, the first listing expired after a year. We're 363 days into the second year of this listing. And I'm just taking a wild guess here, but my guess is it's going to expire in 2 days. And so lo and behold, guess what expires after 2 days? This listing, right? And so then our broker waited a week after it expired, and he goes up to the sellers. He goes and knocks on their door and says, hey, I'm the broker that had the buyer, that we submitted this offer. We were too far apart. However, now that your listing is expired, right, we might be able to put this deal together, save some commission dollars, and make the deal work, because now we're going to be able to cut your other broker out of the deal. Well, the problem was, and what we didn't know, and what the sellers didn't tell us, was that Mrs. Seller had actually signed an amend extend, extending the listing for another year, right? And Mr. Seller hadn't signed it. And the listing broker never re-entered the information in the MLS, never switched it back to active status. She had taken her sign down away from the property. She had taken her lockbox off, right? So as far as we knew, it was truly expired. But part of the reason we got popped in that case was because the sellers provided a copy of their listing contract with the listing broker, right? And our broker then looked at that and said, okay, yep, based on what I see, your listing is expired. And so we got popped because our broker was providing legal advice on a contract that was written by another brokerage firm. Whether his interpretation was correct or not doesn't matter. You have no authority to interpret another brokerage's contract. The caveat, of course, is if you're the listing broker and a buyer's broker presents an offer on your listing, right? Of course, you have to present that to your seller, right? But trying to interpret a contract between former listing broker and seller, when I have no authority to do that, that's providing legal advice. And so our broker got popped with that. And we ended up having to split the commission on that deal, even though our broker's interpretation appeared to be correct as far as we knew. But what we didn't know was Mrs. Seller had signed an extension for a year. Okay. So ugly position to be in. The bottom line is you just don't interpret other brokers' forms, period, unless of course it's an offer on your listing or something. But as far as their exclusive right to buy, their exclusive right to sell, I don't want to see it. I don't want to have a copy of it. I don't want to touch it. I don't want to advise you how to get out of it. Nothing, right? You need to be aware of your status with your broker. If you're confident that it has expired or that you have, effectively terminated it or whatever, that's fine. We can sign a listing agreement today, but I'm advising you that you may be liable to pay a commission here if the other broker comes back and tries to claim that they're entitled to the commission. Okay, so just don't advise on another broker's forms, period. Okay. Let's see, where were we? Let's see, counterpart. So effectively what a counterpart is, right, is let's say that I have 2 buyers, right, and then myself as a listing broker. What I can do is I can take one copy and have Billy buyer and Betsy buyer sign that copy, right? And then I have a completely separate copy, but everything else is the same, right? And I sign this contract, then we take those 2 and merge them together, and that's okay. It doesn't all have to physically be on the same, contract. As long as the contracts are the same, I can sign one copy, they can sign one copy, we can take that together, and that counts as an executed contract. Entire agreement. So again, this agreement constitutes the entire agreement between the parties, and any prior agreements, whether oral or written, have been merged and integrated into this buyer listing contract. So again, this is where you got to be careful. We don't want you making, oral agreements outside of this contract, because let me share this again here. So if we go up to section 5, one of the things that it says that we have to do is perform the terms of any written or oral agreement with a buyer. And so this is one of our brokerage duties. And so even if we have an oral agreement with a buyer, we're still supposed to perform the terms of that agreement, right? But if we come down here, what it says is any agreements, whether written or oral, have been merged and integrated into this buyer listing contract. And so what I don't want you to do is I don't want you to have all of these oral agreements. Hey, I'll do this, I'll do that, right? Whatever else, and then not write them into your listing agreement so that you don't have to do them, because you can still get popped, right? It's very hard to prove, but if it can be proved that you had an oral agreement to do something for your buyer, or seller, if we're talking about the exclusive right to sell, if it can be proved, then you could still be popped for not doing your brokerage duties to your client. Okay. So anything that you're going to agree to, try to write it into the contract so that it's very clear. Hey, this is what we've agreed to. There are no other outside written or oral agreements outside of the contract. This is what it is. Okay. Copy of the contract, and this goes for any contract that your clients sign. You need to provide them with a copy of it. Electronic is fine, hard copy is fine, but you need to provide your clients with a copy of everything that they've signed. Okay. And then Megan's Law. So if the buyer is concerned about the presence of a registered sex offender, then it's up to them to contact local law enforcement, or, look at whatever other sources they, are comfortable with to determine whether a registered sex offender is present in the area or not. Guys, from working in law enforcement, I'll tell you, just because there are no registered sex offenders in the area doesn't mean that there's no sex offenders in the area. It just means they haven't registered. So, be very careful about advising a buyer like, oh, this is a super safe neighborhood, right? There's no sex offenders here. There's like, how do you know? And I'll just frankly tell you, you don't know, right? It could be your neighbor. It could be the person across the street. It could be anybody else. Maybe they haven't been caught yet. Maybe they're not registered, whatever it is, right? So be very careful when you're talking about, oh, this is a safe neighborhood. There's no sex offenders. Same thing with schools. Like, oh yeah, these are great schools. Like, the one time that you tell somebody that, oh yeah, this neighborhood has the best schools in the area, they're going to get the worst teacher, or they're going to get the teacher that, is a sexual predator or whatever happens, right? And then they're like, fall back on you. Gary, you told me that this was the best school in the area. I like the one time that you mentioned something, it's going to come back to bite you. Okay. So just be careful about all that stuff. Broker term authorizes you as the broker to execute the listing contract on behalf of the brokerage firm. And then obviously you'll have signatures and dates. Maybe not as big of a deal on the exclusive right to buy and exclusive right to sell. But I typically will remove all of this information from the contract, the contract to buy and sell anyway, because I don't want to provide the listing broker. If I have the buyer, I don't want to provide the listing broker with my client's name and phone number and address and email and all that other stuff. And, while you're under contract on a transaction, they can't be talking to your buyer, right? That would be sign crossing. But after the deal is done, guess what a good broker is going to do?
Go back and look at it. Right.
I'm going to add your client to my database. Okay. So be careful about providing your client's information in those contracts. I know if you write your contracts in Iris, if you put in all of your clients' name, phone number, address, email, whatever, right? All of that information gets sucked through into the contract to buy and sell, and you can delete it out of there. But if you forget to delete it or whatever, it's going to the other broker when you submit the offer. Okay. So I take it out. You got to be a little bit careful, because part of the problem with doing that is when we talk about notice, right, and providing notice, effectively what these notice sections say is that electronic delivery of these documents and notice can be delivered to the email at the email address of the recipient. Well, where is the email address of the recipient? How do we know that we got it to the right place, right? It's probably defined down here. And so, same thing with physical delivery, right? We could physically deliver it to their street address, at their fax number. So you have to know and understand the balance there. If you're going to, it's not a bad idea to leave it in your exclusive right to buy and exclusive right to sell. But generally speaking, you want to take it out of your contract to buy and sell. Okay.
Jesse, can we back up for a minute?
Yeah, to what?
That provide a copy, since I use DocuSign, and once my clients, my buyers, finish doing a form, it says, would you like a copy?
Yeah.
So I don't physically give them another copy. I just let them make their copies. And especially if you're going green and you're, stating that up front, we're trying to, use less paper. I don't
Yep.
physically give them a copy of everything when we go to closing. I just let them copy what
Perfect.
you want.
Yeah, perfectly okay. Again, the standard in our contract is that electronic delivery is okay. And so unless you're striking through those sections because your client requests physical delivery of these,
Right.
notices and documents, right? Unless you're striking through all that stuff, that's perfectly acceptable. Some brokers will still print off everything right at the closing table so that it's all in one nice folder and it's all together, whatever else. I've seen some brokers back in the day when CDs were a thing, right? They'd burn them all onto a CD so that all the documents were on a CD. Now some brokers will put them on a flash drive so that they can access them all on a flash drive. Like, doesn't matter to me how you do it, but bottom line is your client needs to have access to copies of everything they've signed. Okay. So any questions at all about exclusive right to sell or exclusive right to buy rather? Okay, I know that's way early, but we'll cut it off there today. I don't want to get started on another one and not get very far. So next week we'll start on exclusive right to sell. We'll go a little bit faster through it just because there's a lot of sections that are very similar, nearly identical to the exclusive right to buy. Certainly we'll hit on all the sections that are different from the exclusive right to buy, but we will go a little bit faster through the exclusive right to sell. You guys have any questions about anything else, any other contracts, any weird situations come up, questions you guys have, stories, whatever?
So Jesse, I did a closing on a FHA and let's see, I think it's one thing when you're sitting in your classes and you're taking all this stuff in, but it's quite another when you're actually walking through it in a transaction. So now I know what it means when you have an FHA client, they're under contract, they go to do their appraisal, they've already done their inspection, but that appraiser has conditions based on the loan that need to be met before you can close on this deal. So it's totally separate, and you helped me on that one. We had to rewrite a few things, but now I know what that means. Here's the inspection, but there are these other little conditions over here, even though they're an appraiser, they're not an inspector, that still have to be met. So now I take notes when I do a transaction. Okay, this is FHA. Make sure you watch this, 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 and this. So now I push that appraisal date. I mean, if I have another one, I'm pushing it out there, but still give enough time in those dates and deadlines for whatever conditions could come up, that you have enough time to meet those, barring weather, barring COVID, barring whatever.
Yeah.
So definitely learned on that one.
Yeah, regardless of how long you sit here and listen to me drone on about contracts, like there's always things that are going to come up over the course of a transaction that either I just haven't covered, or it's unique enough that I don't cover it in a group setting or whatever. And what Jerry's talking about, particularly with regards to FHA or VA, is that the appraiser does their own, they call it an inspection, and it's not an inspection like a home inspector does an inspection, but they're supposed to verify, like, the roof is in good shape. They're supposed to do a head and shoulders inspection of the attic, meaning like I at least have to poke my head up in the attic and look and see, is there any, leaking, or is there, anything that I see wrong up here? They have to make sure there's no open, outlets where the outlets don't have face plates, right? These are all things that they're looking for: peeling paint, open junction boxes, like. And so it's not really an inspection like a home inspector, but they do have the ability to effectively red flag something on a transaction. And if that doesn't get taken care of, then you can't get the loan. And so what a lot of people don't realize is that the verbiage in the contract effectively says, once you make it known to the other party that there are they call them lender requirements, even though it's from the appraiser, right? It's called a lender requirement. And so once you notify the other party of these lender requirements that got red flagged by the appraiser, your contract will die within, I think it's 3 business days. I'll have to look, but it will die if you don't have written resolution. Now, it doesn't mean that those things have to be fixed by 3 days or 5 days or whatever the number is in the contract, right? But it does mean you have to have a written resolution of those things. Otherwise, your contract dies, right? And so if I notified Jerry and said, hey, Jerry, you know, we had the appraiser came out, and it turns out that there's 2 outlets that don't have faceplates on them. We need that to be corrected, right? Well, now I've notified her of those lender requirements. Now my clock starts ticking. And if we don't sign some kind of agreement, our contract automatically terminates, right? Once we hit that deadline. And so very tricky, particularly when there's a backup offer on the table. And, you know, it can really suck for an FHA or VA buyer who, you know, let's say we submit our offer and our offer is 400,000, and then lo and behold, you know, Jerry gets an offer at 410,000, and I've submitted these lender requirements to her. And then Jerry's sellers are like, hey, we want to work with this $410,000 offer, right? So we're not going to sign an agreement. Well, our deal terminates, assuming they don't sign some written agreement. And now they move on to, you know, backup offer number, you know, the offer number 2, the backup offer, automatically once our contract terminates. We have no way to get back in. So yeah, got to be careful, got to understand that your contract effectively dies if you don't have a written resolution by your deadline. Okay.
So Jesse, is that why we're seeing FHA and VA buyers not really getting offers accepted?
Well, so I think that's part of it, but another part that really, if brokers understand FHA and VA, right? FHA and VA both effectively have what's called an escape clause. And what the escape clause says is, hey, if the buyer, you know, if the appraisal comes in below the contract price, the buyer gets to walk and they get their earnest money back. Okay. And so there have been brokers who go, you know what, I'm going to outsmart this escape clause, right? And I'm going to say, you know, that the buyer's earnest money is non-refundable right from the get-go, or I'm going to add a provision that says, you know, in regards to the escape clause, buyer, you know, agrees to waive the escape clause or whatever else. Well, the problem with that is that is all set by federal statutes. Okay. And so just because a buyer might agree to waive that escape clause doesn't mean that the seller can enforce it. Now, the buyer can still choose to uphold, right? Like if let's say there's an appraisal gap clause, a VA buyer says, hey, here's our offer for 400,000. If the appraisal comes in short, we'll pay $15,000 over the appraisal. Okay. And lo and behold, our offer of 400,000, the appraisal comes in at 390. Okay. You're within their $15,000 appraisal gap, but guess what? Buyer has a right to terminate and get out if they want to. Now, the hope is that they would abide by the terms of that appraisal gap clause and pay the $10,000 that they're short because they'd agreed to 15 and you're only $10,000 apart, right? So the hope is, hey, they're going to pay it. But if the buyer just says, hey, you know what, our appraisal came in less than our contract price and we really don't want to squeeze ourselves that tight, we were kind of banking on it coming in at 400. We didn't think we'd get a low appraisal. Like, they terminate and they get their earnest money back. And if the seller tries to enforce it, then they're going to have the full weight of the VA against them in a lawsuit.
So I had heard that they weren't allowed to do appraisal gaps if they had a VA loan.
It's not that they're not allowed to. It's not like they're illegal or anything. It's just that a seller can't enforce it. Again, a buyer can choose to abide by the term. You know, there's nothing that says a VA buyer cannot pay more than the appraised value. They can absolutely pay more than the appraised value, right? But if a seller tries to enforce that against them, the VA is going to come after them, because just because a buyer and seller agree to something doesn't mean that it's enforceable. particularly when it's set by federal statutes, right? It would be like, I use the example, it would be like a buyer and seller agreeing that the buyer is going to pay a portion of the purchase price to the seller in meth instead of dollars, right? Well, if the buyer says, hey, I'm not going to pay it in meth, I'm going to pay it in dollars, the seller can't go to the court and say, hey, we have this agreement, the buyer was going to pay part of the property, part of the purchase price in meth. Court's going to laugh at them, right? It's not enforceable. Okay. So same thing, seller, if the buyer wants to terminate based on a low appraisal and get their earnest money back, they can. The hope is that they don't, but it's hard to advise a seller to take an FHA or a VA offer when you have a conventional offer that all else is equal, right? Because in this market where, appraisals are a real problem because, property values keep skyrocketing and buyers keep, going way over market value and bringing in cash to closing and everything else, it's just becoming a huge problem, right? And knowing that appraisals are a huge problem, it's just risky to take on an FHA or a VA deal when there's these escape clauses that there's no workaround for.
So I just have a question about that, but with a conventional loan, because on our last listing, they offered way above asking and offered full appraisal gap coverage and removed the deadlines.
Okay.
But they still kind of wanted us to meet them when the appraisal came in like 300,000 short.
So I would take their earnest money. I mean, if that's what they agreed to, then that's what they agreed to. Now, obviously, if you're going to terminate the contract based on a buyer's breach, then you're going to start back over at square one with somebody else. And that may not be something that, the sellers want to do. And that may not be something that the sellers have time to do. And so, if that's the case, the sellers are in a time crunch, they're in a pinch, and they just have to get it done with buyer number one because they don't have time to figure something out with somebody else. Then the buyer has the seller in a good position to get them to negotiate, right? But if the seller has the ability to, say, hey, you agree to a full appraisal gap, we're $300,000 short, you bring $300,000 cash. Otherwise, if you're not going to, you're in default per the terms of the contract. I'm keeping your earnest money and I'm going to go move on to somebody else. The other part of that is what else do you have on the table, right? And how much is their earnest money? If their earnest money is $1,000, like seller still doesn't have a lot to show for it. And if your next best offer was $400,000 short, then seller's still better off closing up with buyer number one. So there's a lot of like variables that come into play there that you need to, understand how to advise your client. But if that's what they agreed to and the appraisal came in $300,000 short and they don't want to do it, their earnest money's at risk.
Luckily, they had the cash to do it and we didn't have to do that. And we had other great offers too that we could have went back to. But I just worry when everything's going so far over list and everyone's offering these unlimited appraisal gaps with no dates, with all the outs for buyers and contracts that, I don't know.
And that's part of why buyers are just, FHA, VA, even conventional buyers, right? Like they're having a hard time getting stuff locked down because you have a cash offer come in that has no financing and no appraisal. Like the contract price is the contract price and nobody cares what, some third party appraiser thinks about the value, right? And so even if you have a conventional buyer, if they still got to get an appraisal, like what happens if it comes in $100,000 short and the buyer was sure, like, hey, it's not going to be more than $50,000 short and I can put $50,000 up if I have to. And then it comes in that $100,000 short. Now they can't perform, right? So it's brutal out there being a buyer. And especially if you have an FHA, VA buyer, it's just hard to get them accepted. We did have 2 people post in the Northern Colorado page today, like, hey, we had a VA buyer get accepted or an FHA buyer get accepted. So, we'll see, is the market slowing down or is there more inventory coming on board? Are buyers getting burnt out and dropping out of the market? I don't know. And I think it's still going to be tight for a while here. I don't think this is going to go away overnight. I don't think this is like a, hit the wall and drop off a cliff type of, deal. but stick with it. You know, I always try to prep my FHA VA buyers, like, you need to you know, be prepared for the fact that we're going to lose multiple offers probably, right? And we're going to have to write multiple offers. Don't get discouraged, right? It's just going to be a thing that we're in it for the long haul, right? Hopefully somebody is sympathetic to your situation and they don't want to sell it to the cash investor or whatever, but it's a difficult process for FHA and VA buyers right now, or buyers with a 3%, 5% conventional who just don't have a lot of money to throw at an appraisal gap. So kind of sucks.
Jesse, I had a buyer that was on a higher price point too, and she was just, I mean, trust me, it was higher, put in multiple offers, and she just got tired of the emotional roller coaster, and she said, I'm gonna stop for now, because she couldn't do that anymore. And it wasn't low end, it was higher end, and I can't do this, so.
Yeah. And what sucks is, like, in those higher price ranges, a lot of times those buyers have a larger financial cushion too. And so instead of a $10,000 appraisal gap or a $20,000 appraisal gap, they're coming in with like $100,000 appraisal gap, right? There was one at the Castle Rock office that was like $200,000 full guarantee. Yeah, 200,000 plus full guarantee. Like, how do you compete with that? That's crazy.
Not only that, but aren't you going to be underwater for a while? I mean,
Right.
Well, your home now becomes its own best comp, right? And so you've now set market value. Doesn't mean that someone else is going to get that, and it doesn't mean that someone else can't sell for less, right? But I don't know. I mean, in the long run, are you going to lose it or not? I mean, in the long run, real estate has always performed well. There's always corrections, and there will be a correction at some point.
that's
But
what I'm worried about. Yeah.
when is it going to be? I don't know. I mean, there's not an end in sight right now, as far as I'm concerned.
How crazy.
I don't have the crystal ball either. So,
Well, you know what too, Jesse, is I had a situation arise where the property next to my listing, my listing was closing like within a week, and the property next to it, they had way overpriced to start with, and they were banking on mine, because mine came in with a $30,000 appraisal gap to where we finally settled in on the final price. They were waiting on mine to close so they could use my comp to ensure they would get their appraisal. And the agent actually called me and he's like, oh, hey, we're just trying to see when you're closing. And the appraiser wants to use our appraiser wants to use your listing as a comp. And I go, you mean the buyer's appraiser wants to use my listing as a comp? And he's like, oh, well, yeah.
Yeah, the seller wants it.
Yeah. And I go, well, we're closing next week, and I never would give him an actual date that we were closing. And then he was trying to press me on the price. Well, my client had already told the neighbor, who was his client, what the price was. And I go, I can't divulge that. I've got fiduciary duty to my client. He goes, well, she told my seller what it closed at. And I go, well, then that's between them.
Yeah.
I mean, it was.
Yeah. So I will tell them when I'm closing, but I generally will not disclose a price to them. I will give them we're over list price, or, close to list price or whatever, but I won't give them a number, because in some cases, what could theoretically happen, right, is even if you verify, yep, they're the listing broker on this property or whatever else, sometimes what happens is they generate a buyer off of their listing, right? And then they want to know what you're under contract for, and then potentially write a backup offer, right, to, screw up your first deal, put leverage against your first deal. Or if your deal falls apart, then they want to come in with their buyer to your deal to write an offer, know like, hey, here's what the seller was willing to accept. And so not a good idea to divulge that stuff to other brokers. I mean, it's okay so if you take a listing and you're in a multiple offer situation, it is okay to divulge that information to other parties, right? Before you go under contract, it's okay to tell them flat out, hey, here's our best offer. Our best offer right now is at 450, right? It's okay to tell that to all the brokers. And then if they want to beat 450, great. And then someone comes in at 460, right? Tell everybody, hey, our best offer is at 460. That's okay to do. But once you go under contract, I typically keep that under wraps, because what I don't want to have happen is my deal falls apart, and lo and behold, I told this other broker, hey, here's what we were under contract for. And then they write an offer knowing what the seller is willing to accept, right?
Yeah.
Right.
What about, I hear a lot lately about how many offers have you gotten?
Yeah.
Sort of a
So,
new,
yeah, and let me backtrack a little bit. In your exclusive right to sell, there's a checkbox that says, does the listing broker have the right to disclose other offers, or do they not? You need to have that box checked if you're going to disclose, the presence of other offers, the price, the terms of other offers, all that other stuff. And so how many other offers do you have? I will tell them, yep, we've got 4 offers on the table or whatever. I will let them know so that they know to be competitive in their offer. That being said, if you call me on my listing and say, hey, Jesse, how many offers do you have? And I tell you we have 7 offers on the table, do you believe me?
I would believe you, Jesse.
You're
what?
Yes.
okay. You're naive,
Yeah.
and I probably wouldn't lie to you, but there are brokers out there that,
Yes.
I'll rephrase this. If you ask Joe Broker, hey, how many offers do you have on the table? Do you believe him right off the bat?
Heck no.
So, I mean, write your client's best offer if it's a multiple offer situation, or you expect that it's going to be a multiple offer situation, right? Like, what difference does it make whether I have 7 offers or 3 offers or 1? If your client wants it and it's a multiple offer situation, have them write the best offer they can, right? So, I mean, you don't want to leave any money on the table, and I get that. I understand that. But if they want the house that bad and it's the property for them and whatever else, if they're willing to pay it, they're willing to pay it, right? Go to bat and have them compete. So, yeah, be careful about how you advise your clients in multiple offer situations, right? It's just, this market is crazy, and it's creating a lot of mischief for brokers. I don't know if you guys saw do you guys know who Scott Peterson is? He's the general counsel for the Colorado Association of Realtors. He just did he does these legal bites videos, and he just did one yesterday about inspection waivers, where buyers are effectively agreeing to waive, all of the inspection objection, termination, and resolution. And, he's like, I get it from a buyer's perspective, right? They want to be competitive, and they want to, make their offer attractive to the seller. And he's like, let's look at it from the seller side though, right? If you look at it from the seller side, if you've negotiated, right, that the buyer is waiving all of those inspection, objection, termination, resolution, everything else, the buyer is effectively relying 100% on the fact that the seller has disclosed anything and everything that could possibly be considered an adverse material fact. And if the seller hasn't done that, it's almost a done deal as far as getting sued by the buyer and saying, hey, you failed to disclose an adverse material fact that you knew about, and we negotiated that I would waive my inspection. I fully relied on your disclosure, and you didn't disclose it. Your seller is getting sued. So, what probably the best practice, right, is to advise a buyer, hey, you can certainly waive it if you want to be competitive. I don't recommend that you do that, but if you do, that's your choice. It's not me advising it. And then if you're representing a seller where a buyer is coming in saying we're agreeing to waive everything, really the best practice is probably to at least give them back their inspection termination deadline, maybe not their inspection objection and resolution, but at least give them back an inspection termination, that says, hey, buyer, you at least have a right to terminate if you do an inspection and you know, you find something, you can terminate and get your earnest money back, but you have no right to ask me for repairs as part of an objection, right? I'm at least going to let you have the right to terminate. Okay. And then if they choose not to do an inspection and they choose not to terminate and whatever else, at least you have a little bit of a leg to stand on. That's not, oh yeah, I forced the buyer to waive their inspection, objection, termination, and resolution. And then I didn't disclose what I should have disclosed on the property disclosure and everything else, right? It's just an ugly situation for a seller to be in. So, you know, I mean, if your seller isn't going to go that far, you might at least add a provision that says, hey, even though buyer is waiving their objection, termination, and resolution, buyer has a right to have an inspection for their own peace of mind. And then they can terminate, they just lose their earnest money, but at least they had an opportunity to inspect, and I didn't force them to not even be able to get an inspection, right? So what else? You guys have other questions? Anything else?
Can we talk about when you could possibly do a CMA, Jesse? It'd be a good refresher right now.
Yeah, June
How
25th
you
from 10 to 12:30.
Good, thank you. Hey, I have a diesel motor.
But for Castle Rock people, that's an in-person thing. So we'll set something up for down south. So yep, northern offices, June 25th. I know that's still a little ways out, but that was really the first opportunity we could get it on the calendar. So June 25th, 10 to 12:30. All right, any other questions? Otherwise, we'll end early. Okay, we'll pick it up next week with exclusive right to sell, and we'll see you guys then.
Thanks, Jesse.
Yeah, you bet. We'll see you guys.